on these items.
Your Honor,
Um,
please.
Yes, what is the pleasure of the counsel for the prosecution, panel of prosecutors rather?
May we suggest, Your Honor, for orderly procedure, that we go over our proposed stipulations and then they can respond accordingly, because we also would like this honorable court, impeachment court, to appreciate the documents that will be stipulated upon, which are as important as compared as well to the documents that will not be stipulated upon, Your Honor. They will be very short in any event, Your Honor.
Counsel, stipulation does not mean that you will not present it before the witness anymore for whatever purpose it may serve.
Yes, Your Honor. It does not, these stipulations will not dispense with the need for the witness to testify and to identify the document and to attest as to its contents, Your Honor.
So just as to the authenticity of these documents and due
Yes, Your
execution,
Honor.
I guess, that's what the stipulation is being asked for? So let's go through your list, counsel.
Okay.
Chair will instruct the counsel for the panel of prosecutors to kindly go over the list and maybe elicit a response from the counsel for respondent, whether they will stipulate or not. And you don't need to cite a reason, but you may do so also if you desire. Attorney Capunan, you may proceed, ma'am.
With the permission of this honorable court, flashed on the screen for easy reference is a letter response dated March 13, 2024. This is Exhibit P-1-13B. And for the defense, this is Exhibit 1-120-OVP, stipulated, Your Honor.
we stipulate, Your Honor.
So noted, duly noted rather. Attorney Capunan.
Next, Your Honor, is a notice of disallowance dated August 8, 2024, which is Exhibit P-1-13-C. And for the defense, it is Exhibit 1-108 OVP, stipulated, Your Honor.
We stipulate, Your Honor.
Noted.
The next is Exhibit P-1-12-F, which is the response dated April 19, 2024, Your Honor. This is Defense Exhibit 1-115, Office of the Vice President and Series.
Attorney Christine,
I'm sorry, Your Honor. Can I confer with my
you may do so.
counsel? We do not stipulate, Your Honor.
Proceed, counsel. Attorney Capunan.
Next, Your Honor, we have acknowledgement receipts for the periods February 6 to 30, 2023, and April 25 to June 30, 2023. For the appreciation of this honorable court, Your Honor, this is Exhibits P-1-8-850 to P-1-8-1714. Representing the first quarter documents of the Office of the President and the second documents of the Office of the Vice President. The first quarter is 519 documents. The second quarter is 530 documents, or a total of 1,049 documents, Your Honor.
Counsel, the copy you gave me is different from what you just read. The copy I have is Exhibits P1-8-849 to P1-8 to 1898. And it covers ARs for the period February 6 to March 29, 2023 for the first quarter, and April 25 to June 30, 2023 for the second quarter. That is different from what you are showing on the screen, counsel.
Yes, Your Honor. My bad. It's what is flashed on the screen, Your Honor. The presiding officer is correct, Your Honor. But in any event, these are the same number of documents, totaling 1,049.
I bring that up, counsel, because that is, I guess, the same copy that counsel for the respondent has, what I have. Would that be correct?
No, Your Honor. We have our own copies of the
No,
exhibits.
do you have
which
the
we mark.
same? Is the copy that counsel for the panel of prosecutors? Is it
Yes,
the same
yes.
copy?
The list, Your Honor. Yes.
The
We
same
confirm
copy as
that.
the presiding officer has, not the one flashed on the screen.
Yes, Your Honor. I confirm that.
So you're asking for stipulation for the ones I mentioned, the ARs for the periods I mentioned, February 6 to March 29, 2023, and April 25 to June 30, 2023. Do you stipulate, counsel?
We do not stipulate, Your Honor.
Move on, Attorney Kapunan.
Your Honor, in connection with this, as in the first witness yesterday, since the presiding officer did point us to the particular provision in the rules of court, which is Rule 130, 3C and 3D, Your Honor, with reference to voluminous documents which would take a lot of just to mention ahead of time
That is
we
correct.
will by this witness, Your Honor.
That is in section 3C in relation to section 7.
Yes. Exhibit P-1-12-G, which is a certification of the VP SPG, Your Honor, VP SPG certification dated April 4, 2024, which is Defense Exhibit 1-91, stipulated, Your Honor.
We stipulate, Your Honor.
Duly noted.
We have the Protective Intelligence Operation Report for the engagement of respondents Duterte and the Vice Presidential Security and Protection Group for the first quarter of 2023. And these are exhibits -1-12-H up to P-12-H-9, which is Defense Exhibit 1-115 OVP and series, Your Honor. We have been told that counsel will not stipulate to this, Your Honor.
That is correct, Your Honor.
May we know the reason, Your Honor?
Your Honor, we do not stipulate on this because these documents that they marked are incomplete. Hence, they will not truthfully reflect, Your Honor, what the document is. So we do not stipulate, Your Honor.
Actually, to abbreviate the proceedings, counsel, no reason need be given by opposing counsel. Since stipulation is a voluntary act on their part, they may refuse, and any refusal should not be taken against them as well, although it will abbreviate the proceedings. Please proceed, counsel.
Next, Your Honor, is Protective Intelligence Operations Report for the engagements of Respondent Duterte from the Vice Presidential Security Protection Group for the second quarter of 2023, Exhibits P-1-12-M to P-12-M-13, which is Defense Exhibit 115 OVP and series, again, not stipulated upon by the defense, Your Honor.
That is correct, Your Honor.
For
Move
the
on,
court-
counsel. Duly noted. Move on.
Moving on to the third quarter, incidentally, these documents previously mentioned are for the first and second quarter of 2023 Office of the Vice President. We now turn on to the third quarter of 2023 Office of the Vice President. The first exhibit is Audit Observation Memorandum, or AOM, dated August 8, 2024. Prosecution's Exhibit P-1-12-I, Defense Exhibit 1-106, OVP, stipulated upon.
We stipulate, Your Honor.
Noted.
Exhibit P-1-12-J, which is the Office of the Vice President's response dated August 27, 2024. Defense Exhibit 116, OVP and series, not stipulated, Your Honor.
That is correct, Your Honor.
Exhibits P-1-8-1899 up to P-1-8-2672. Acknowledgement receipts for the period July 14 to September 30, 2023 for the third quarter. Not stipulated upon, Your Honor.
That is correct, Your Honor.
Noted.
P-1 Defense Exhibit 1-116 OVP and series not stipulated upon.
Counsel?
Sorry. I think
Certification dated September 30, 2023.
that is stipulated, Your Honor. Not stipulated.
I verify.
I'm sorry?
It
Not
is both
stipulated, Your
stipulated.
Honor.
and
Not stipulated.
It is not stipulated, Counsel.
Yes, not stipulated.
Not stipulated.
Exhibits, thank you. Exhibit P-1-12-11 up to P-1-12-110. Protective Intelligence Operations Report. Third quarter of 2023, which is an attachment to the OVP's response dated August 27, 2024, not stipulated upon.
That is correct, Your Honor.
Notice of disallowance.
Before you continue, counsel, I remember, Attorney Christine, that you had 8 of these proposed documents for stipulation you will not stipulate on.
Actually, Your Honor,
more.
it's 10.
10.
Yes.
With the permission of Attorney Kapunan, let's try to abbreviate the proceedings. What are the remaining 2 that you will not stipulate on?
Your Honor, it's exhibits P-1-17-5 to P-1-17-1229.
These are the acknowledgement receipts
Yes,
for the
Your
period
Honor.
of February 20 to March 30, 2023 and April 20 to June 29, 2023.
Correct, Your Honor.
And the last one?
And the last one is the acknowledgement receipts for the period July 12 to September 30, 2023, Your Honor. Marked as exhibits P-1-17, 1233 to P-1-17, 1894.
The rest you stipulate on,
Correct, Your Honor.
which I will read for the record. With the permission of Attorney Lorna,
Yes,
counsel
Your
for the
Honor.
panel of prosecutors. Counsel for respondents stipulates on the following documents. Exhibit P-1-13-F, notice of disallowance dated March 31, 2026, also marked as exhibits, the respondents exhibit 1-9. Exhibit P-1-21B, response dated April 17, 2024, marked as respondents exhibit 1-90. Exhibit P-I-22A, certification dated 11 January 2024, issued by Colonel Manaros M. Boransing II, marked as respondent exhibit 1-74. Exhibit P-I-1-22B, certification dated December 30, 2023, issued by Colonel Carlos B. Sangdaan Jr., marked as likewise marked as respondents exhibit 1-75. Exhibit P-1-22C, certification dated December 5, 2023, issued by Colonel Magtanggol Panopio, also marked as respondents exhibit 1-76. Exhibit P-1-22D for the prosecution and exhibit 1-84DE for the respondent, a certification issued, undated certification issued by Colonel Adonis Bajao or Bahao. Exhibit P-1-21C, AUM dated August 8, 2024, also marked as Exhibit 1-106 OVP. Exhibit P-1-21D, response dated August 27, 2024, also respondents 1-93DE exhibit. Exhibit P-1-22E, certification dated September 25, 2023, issued by Jaicris Jan P. Mendoza, also respondents exhibit 1-97DE. Exhibit P-1-22F, certification dated December 10, issued also by Jaicris Jan Mendoza, also respondents 1-96-DE. Exhibit P-1 Bajao, also respondents exhibit 1-94DE. And finally, Exhibit P-1-22H certification dated July 1, 2024, issued by Darren E. Comia, also respondents Exhibit 1-95-DE. Would that be correct, Attorney Christine?
Yes, Your Honor. We confirm the enumeration, Your Honor.
You may proceed, Counsel.
Thank you for that, Mr. Presiding Officer. But for the better understanding of this honorable court, the acknowledgement receipts which counsel for the defense has not agreed to testify on are as follows, Your Honor. For the first quarter, for the Office of the Vice President, that's 519 documents. For the second quarter, 530 documents. For the third quarter of 2023, 774 documents, Your Honor. And if we include the 845 documents identified by Mr. Wamil yesterday, for the fourth quarter of 2022, this court will have to appreciate that counsel for the defense refused to stipulate on, well, it is the right, 2,668 documents, Your Honor. And for the DepEd receipts for the second quarter, Your Honor, 619 acknowledgement receipts, and for the third quarter, 644 acknowledgement receipts, or to summarize, 1,824 acknowledgement receipts of the Department of Education Office, which they themselves submitted to the COA ICFAO, or a total for the Office of the Vice President and the DepEd, 4,492 documents contained in 15 boxes, Your Honor.
Hindi mo naman siguro kami tinatakot, Attorney Gapono.
Ay, hindi po. I am,
Kindly proceed, Counsel.
and also, Your Honor, the reason I made manifestation of this is we will not present the 15 boxes. We will present, the witness will identify this, but we will be presenting in lieu thereof 3 tabulations. 4. 6. 6 summaries, Your Honor. 6 summaries prepared by this witness for the 4,492 documents, Your Honor, which will be identified in due course of the testimony together with the acknowledgement receipt, Your Honor. With the permission of this honorable court.
As earlier ruled by the court, we will allow the witness to testify from a table and or summaries given the voluminous nature of the documents that she may or will be testifying to. Counsel may proceed with her direct examination. Offer rather first.
Your Honor, please. We likewise request the following stipulations, Your Honor, in addition to these documents, that the witness has taken over the audit of the liquidation documents of the Office of the Vice President for December 21 to 31, 2022, and the first to third quarters of 2023.
Counsel took over from what?
From Mr. Wamil.
From December, meaning he took over.
Has taken over the audit liquidation documents turned over by Mr. Wamil for this period, Your Honor.
Presumably when Mr. Wamil retired?
Yes, Your Honor.
Can you give the date when she took over? Mr. Wamil retired February of 2024, if I'm not mistaken.
Yes, Your Honor. February 12, 2024.
Up to today.
Up to the present, Your Honor, where he now serves in the COA Pasay, Your Honor.
What does counsel for the respondent say?
Your Honor, we cannot stipulate on that because we are not from COA, so we're not privy, Your Honor, to any of the resolutions or memoranda that were
Witness-
issued with respect to the assignment of their employees, Your Honor.
Witness can testify to that later on. Move on for other requested stipulations, counsel. If any.
That the witness is competent to testify as to the documents that they themselves, the Office of the Vice President and the DepEd, submitted by way of liquidation documents to the COA ICFAO.
Can I comment on that, Your Honor?
Yes.
We will
counsel.
not stipulate on that, Your Honor, because they have to establish the competence of that witness to identify the documents.
Move on, counsel.
Your Honor, we will not proceed with the other stipulations because counsel does not seem to be in the mood to stipulate this afternoon, Your Honor.
Your Honor,
It has
please.
no relation with mood, counsel.
Okay, we will now go
The
on.
counsel for the respondent is well within their rights to
Correct, Your
refuse
Honor.
stipulation because this is purely mutual on the part of both parties. Your time will come too. Please proceed with your offer, counsel.
This testimony of this witness, Your Honor, is being offered for the following. First, that Ms. Silene May L. Del Campo is a state auditor of the Commission on Audit, Intelligence, and Confidential Funds Audit Office. Second, that Ms. Del Campo was assigned to take over the audit of the OVP's liquidation of its confidential funds from Attorney Roderick Wamil, Your Honor. For easy appreciation of this honorable court, the purposes are being flashed on the screen, Your Honor. In this, well, that siya po ang nagtuloy ng inumpisahan ni Mr. Roderick Wamil na evaluation ng confidential.
Chair would just like to correct the earlier statement with your indulgence, Attorney Kapunan. Mr. Rommel did not retire on February 2024. He was transferred to another office within
Yes,
COA.
Your Honor.
Yes, please proceed.
That Ms. Del Campo evaluated the response of the Office of the Vice President to the notice of suspension dated December 13, 2023, which was issued in relation to the OVP's liquidation of its confidential funds for December 2022. Number 4, that this witness found that the response of the Office of the Vice President to the notice of suspension dated December 13, 2023 is a violation and still non-compliant with Joint Circular 2015-01. Number 5, that it was pursuant to this witness evaluation and recommendations that the notice of disallowance dated August 8, 2024 was issued by the Office of the Vice President. Number 6, that Ms. Del Campo took over the audit of the Office of the Vice President responses to the Audit Observation Memorandum dated February 1, 2024, covering the first and second quarters of 2023, and AOM dated August 8, 2024, covering the third quarter of 2023. That thereafter, a notice of disallowance dated March 31, 2026 was issued to the Office of the Vice President for the liquidation of its confidential funds covering the first to the third quarter of 2023. This witness also took over the audit of the Department of Education's responses to the Audit Observation Memorandum dated February 1, 2024. This covers the period the first quarter and the second quarter of 2023, and an AOM dated August 8, 2024, which covers the third quarter of 2023 for the Department of Education. Likewise, Your Honor, this witness will testify and authenticate such other documents and will attest to such other matters as are relevant and material to this impeachment case.
Comment on the part of counsel for respondent?
Subject to cross-examination, Your Honor.
Subject to cross, counsel may proceed with her direct when she is ready.
Thank you. Thank you, counsel. Madam Witness, can you again please state, pakisabi ulit, anong pangalan natin, your age, your occupation, and other personal circumstances?
I am Silene May L. Del Campo, 36 years old, a state auditor currently assigned in the Intelligence and Confidential Fund Audit Office of the Commission on Audit.
Okay. Will you be testifying in English or Filipino or both, Madam Witness?
In both languages po.
Okay. With that permission, Your Honor. Please tell us, Madam Witness, Miss Silene, ano ba ang educational background natin?
Ako po ay nagtapos ng Bachelor of Science in Accountancy degree sa St. Louis University po.
Okay. And you said earlier that ngayon ikaw ay state auditor na ng COA, ICFAO, Intelligence and Confidential Funds Audit Office, correct?
Opo.
Okay. Can you tell us, before you became state auditor to this current position, meron ka bang ibang position sa COA?
Wala na po akong naging ibang posisyon sa COA.
And when did you start therefore? You're being a state auditor of the COA, ICFAO.
Nagsimula po ako noong August 26, 2014.
August 26, 2014. Okay.
Opo.
Just to remind us all, ano ba ang functions nung COA ICFAO?
Ang COA ICFAO po ay office under the Office of the Chair agencies po.
Okay. And what are these government agencies that you have audited?
Ang mga na-audit ko po is mga local government units, government-owned and controlled corporations, at saka po mga national government agencies na kasama po dito ang Office of the Vice President at Department of Education.
When you say Office of the Vice President, who? Which Vice President specifically during your term, during your current position from 2014 to the present, which Vice President have you audited in terms of confidential funds?
Nung magsimula po ako sa COA, sa ICFAO, ang na-audit ko lang po na liquidation documents ng Office of the Vice President ay kay Vice President Sara Duterte.
Bakit siya lang, Madam Witness?
Dahil nga po from 2014 hanggang sa ngayon po, yung naisubmit po sa amin na liquidation documents is sa confidential fund po ni VP Sara.
Okay. Mga sinubmit sa inyo.
Apo.
You also mentioned na nag-audit ka sa Office of the DepEd, Department of Education. Sino-sino mga secretaries ng DepEd ang na-audit mo para sa confidential funds?
Namin is liquidation documents sa confidential fund ni Vice President Sara Duterte noong siya ay Secretary of Education.
Okay, bakit? Bakit si Secretary of DepEd Sara Duterte lang?
Dahil po from 2014 to present, siya lang po yung Secretary of Education na may confidential fund.
Let's go now to your current function as State Auditor of the COA ICFAO. And you started when, Madam Witness? Kailan ka nag-umpisa dito?
August 26, 2014 po.
Malalam ba? Sino ang sinundan mo sa position na ito?
Pwede pong pakiulit yung tanong?
You started with this office in August.
Opo, tama po.
And when you started in August, were there any liquidation documents of the Office of the Vice President and the DepEd in that office?
Yes po, meron po.
And did you evaluate them?
Nung umalis po si Mr. Wamil, ako na po ang nagpatuloy ng audit ng mga liquidation documents po ng Office of the Vice President at Department of Education po.
Okay. And pag sinabi mong audit, anong klaseng audit ang ginawa mo or ang ginagawa ng office mo?
Ang audit po na ginagawa ng aming opisina ay post-audit po.
Tell us again, what is a post-audit?
Sa post-audit po na ito, natapos na po yung transaksyon at paggastos ng pondo. Doon na po kami mag-audit. Pag natapos na po ang transaksyon at paggastos ng pondo.
Natapos na yung transaction, nagastos na yung pera, ino-audit nyo. Anong ino-audit nyo?
Ang ino-audit po namin is yung utilization ng confidential and intelligence fund.
Okay. Ngayon, what were these documents that Mr. Wamil left and which you took over with?
Bale po, iniwan po niya sa akin ang mga documents ng OBP for the periods December 21 to 31, 2022. Kasama na rin po ang first to third quarters ng 2023. And for the DepEd po, iniwan din po niya sa akin ang mga documents for the first, second, and third quarters of 2023.
Showing to you, Madam Witness, a tabulation. Merong ginawang tabulation si Mr. Wamil at ito po ay minarkahan natin to cover exhibits P-1-8-1 up to P-1-8-848 covering 845 acknowledgement receipts for the period December 21 to 31, 2022. If shown to you, this tabulation and the supporting acknowledgement receipts, please identify the same.
Opo.
Assisting counsels may approach from both parties.
Your Honor, may we manifest for the record that this witness, Your Honor, is going over, perusing all of these documents, 845 acknowledgement receipts.
Counsel, I thought the witness will simply peruse the table or summary of Mr. Wamil.
Yes, Your Honor, these are the documents. These are the ARs mentioned in the tabulation, which she also is looking at, Your Honor.
Okay, so not just the summary and table prepared by Mr. Wamil, also some samples of the ARs covering the 845 ARs.
She is looking currently at all of these 845 documents, Your Honor. Because, Your Honor, again, counsel for the respondent did not stipulate on these documents. Your Honor, please, for efficient use of time, Your Honor, these ARs are just being shown to the witness, Your Honor, for identification, but counsel for the respondents may certainly go over them one by one after this trial this afternoon, Your Honor.
The manifestation is noted. With the permission of the counsel for the parties, while the witness is perusing the acknowledgement receipts for the period covering December 21 to December 31, 2022, Chair would like to make some some administrative orders to save on the court's time. On the subpoena documents which were submitted to the clerk of court on July 30, 2026, and on those that will be submitted on August 13, pursuant to the request for extension by the two aforementioned banks, namely BDO Unibank and Security Bank. We note that the clerk of court performed merely the mechanical act of receiving the submissions from the subpoenaed institutions, while the subject banks and institutions represented that the documents contained in the USB given to the court are the exact mirror of the hard copies they submitted, which are in turn accurately reflected in their respective document indices. The court has had no opportunity to confirm the same. Therefore, the presiding officer orders the clerk of court to compare the digital and printed copies of the submissions, both as of now and those that will be submitted, and to check them against the list provided for by the banks to make sure that the USBs indeed contain the hard copy submitted before the court and Toto turns it over to the parties in due course. So ordered. Hailin, kamusta ka na? Malapit ka na o hindi pa?
Your Honor, medyo marami pa po.
Two folders na.
With the permission of the counsel, for the panel of prosecutors as well as the counsel for the respondent, we will be adjourning in a few minutes for our afternoon session. So to be able to move on somewhat, the court directs that Hailin go over these documents after today's trial so that when she continues her testimony on Monday, that she can already testify as to those documents, if indeed those are the same documents that she reviewed, perused, and were turned over to her by Attorney Wamil. In the meantime, counsel, perhaps we can proceed with the table of or the summary prepared by either with Mr. Wamil or the witness before we call for adjournment. At least napakinggan natin si Ms. Hailin.
Your Honor, just a quick manifestation, Your Honor.
Yes, counsel for respondent.
Yes, Your Honor. We noted that the list of accounts, which was supposed to be prepared by Mr. Wamil, with the caption OVP, open parenthesis, December 21 to 31, 20 was unsigned and it was undated. Second, the witness is merely flipping the pages without comparing the ARs with the list, Your Honor, to check whether the ARs are the same with what was listed by Mr. Wamil, Your Honor. And the third one is that we note that the folders containing the ARs were not marked as exhibits of the prosecution, Your Honor. For the record, Your Honor.
Duly noted. However, the witness may testify as to the summary and/or table if she's aware of it and if indeed it was part of the documents turned over to her by Mr. Wamil. Counsel for the panel of prosecutors.
Your Honor, we are tempted to make a counter manifestation, Your Honor. Because, Your Honor, these manifestations, Your Honor, are because of their own doing, Your Honor. But in any event,
I hope you won't give in to the temptation, counsel.
I will not. I will not, Your Honor. It's the wisdom of age. I will not.
Let's get something out
Yes,
of
Your
Ms.
Honor.
Eileen.
In fact, Your Honor, may I continue? May we continue to aid this honorable presiding officer that during the interregnum from today's proceedings until Monday, there will be other tabulations, Your Honor, and there will be other acknowledgement receipts. And we propose, Your Honor, and regret that this is not unusual, but it is necessary, Your Honor, that all of these documents, because counsel says that this witness was just flipping over them. They can do this in front of the defense counsels and us, Your Honor, for the next succeeding days, because we will be going over 4,492 documents and six summaries, Your Honor. Hopefully that we will be doing that in the next days out of court so that by Monday it will be a speedier presentation of testimonial evidence, Your Honor.
If you're converting that in, are you making a motion, counsel?
Yes, Your Honor, may we so move that we be allowed to do this, not only as respect to the last quarter of December 2022, which is suggestion of the presiding officer, but to all the quarters, quarter 1, 2, and 3 for the OVP, and quarter 1, 2, and 3 for the DepEd.
Only with respect to the acknowledgement receipts.
Only with respect to, Your Honor, the acknowledgement, the acknowledgement receipts, Your Honor.
Aside from the asked for transfer of markings this afternoon, wala naman kayong mga appointment ng Webes at Biyernes, di ba?
Your Honor, can I comment
Yes,
on that, Your Honor?
counsel for the respondent.
Your Honor, under the rules, the witness has to identify the document in open court. The problem with their stipulation, Your Honor, is that they will be having the witness identify the documents out of court. So therefore, it is no longer part of the trial, and there's a problem when it comes to the offer. There will be a problem when it comes to their offer of evidence, Your Honor. And with regard to the counter manifestation or the statement of counsel that we want to, look at the witness while she's flipping the document, Your Honor. Precisely, that is what we are doing right now, Your Honor. So we object to the proposal that the
The court views it perhaps an opportunity possible as related because of 45. The observation of the respondent was it was simply contained folder in a folder and there was no real for the witness to on the
Yeah.
if the
your not stipulate your we didn't stipulate this, Your Honor, because ARs have been submitted, Your Honor, the OVP and the DepEd no longer had control over these ARs. So therefore, we do not know what were the receipts that were provided by the COA and how many receipts were given to the prosecution, Your Honor. And these are not common exhibits because we did not mark those documents or ARs as our own. We didn't adopt them as our own, Your Honor. And third, the ARs that were presented or are being presented now by the prosecution have not been compared with our own copies. Cannot determine with certainty, Your Honor, if their ARs are actually identical with our copies, Your Honor.
Counsel, that is
we cannot-
precisely the opportunity the court is opening a chance for you to do so, to compare it with your copies of your, if you so desire. I mean, this for the purpose
Your Honor,
of
please,
expediting.
if I may, Your Honor.
Counsel for respondent will please respond first before to the query of the presiding officer before I recognize Attorney Cap. Yes, Attorney Christine, so you do not want to take the opportunity to of the ARs with of the ARs as submitted to COA or as allegedly submitted to COA.
Your Honor, upon team, Your Honor, unfortunately, we cannot do that.
Noted. Attorney Cap, it's your pleasure.
With due indulgence, Your Honor, now I will give in to my presentation. First, Your Honor, what is happening now could have been prevented has exercised in trial. When the asked for stipulation on documents, these included stipulations on the acknowledgement receipts, the opportune time for the defense counsel to have examined page, receipt by receipt, the full reproduction, the AR copies with their own copy, Your Honor. They this opportunity. Now that done more expeditious, a motion that goes, which incidentally I wish to amend that because of it being an out of, may we amend my motion, Your Honor, that it be done in front of the clerk of court and that the clerk of court be duly authorized by authority of the Honorable Court to preside over the session, Your Honor. The same way as clerks of court, designated officers can mediate between the parties as to a possible amicable settlement or stipulation. And this will be, Your Honor, I'm sorry, seeing
Please
them
continue, Counsel.
nodding in acceptance of the motion. Unfortunately,
Sit, Counsel, because he's not forward to the load.
Your
But please
Honor,
proceed.
please. And so, if that is done, Your Honor, then we will be making more efficient use of the time of this honorable court. The marking, the identification by this witness, the comparison of both prosecution markings.
These
and the
ARs have
defense
not been
markings.
individually marked, Counsel.
Your Honor.
They were not yet marked, being showed to the witness.
No, Your Honor. Already, Your Honor, and also have our own marked copies, Your Honor.
They were marked, but so how?
We have separate.
That is precisely my point, Counsel. My point, Counsel. For the clerk, an extended or additional pre-trial. Perhaps this can be.
Yes,
You
Your
need
Honor.
not stick to those that exactly the same. It can be 10 out of 845. 145. Do not know really, quite frankly. But done litigation court stipulation asked for by the counsel for the panel of prosecutors in relation to witness viewing it or looking at it. If it is related, then there is no need for her to peruse, go through but only or the counsel for respondent. I think the client to offer this one more opportunity to stipulate acknowledgement receipts. The court is not forcing the counsel for respondent to stipulate on documents they refuse, but since it pertains to the chain of custody, after you submitted it to the court, then the court will for it. On anything, you don't have to stipulate on a single one, but the court would rather do this to save on the courts without prejudice again to the respondent or counsel saying that they refuse to stipulate because they're different from the copies that counsel.
Actually, we will proposal, Your Honor, but we provided before and the shall be mutually agreed upon by the parties.
Of
Yes, Your Honor. I think,
actually agreed upon between
Your Honor, please.
as far as this is concerned, or give me one date on one time slot on Thursday and Friday which you can agree on after we adjourn.
Your Honor, please, if I may add as well. In the marking of this exhibit, Your Honor, before the Honorable Clerk of Court, each acknowledgement receipt had 3 signatures. The signature of the Clerk of Court, the signature of one of the representatives for the prosecution, and the signature of the defense counsel, Your Honor. 3 signatures per document. And now they still want, they had signed each of these acknowledgement receipts, Your Honor. That's number 1. Number 2, Your Honor, perhaps to restore a level of trust on the side of the defense, maybe we can even use their own documents. If they do not trust the prosecution's documents or photocopies of the prosecution's documents, then we will use their documents, Your Honor, because we are certain that their documents is the same as our documents. Let's use the defense documents, Your Honor. Then they will not say, we do not trust these documents because it is their own defense documents. Maybe that will solve the problem of this court. We will use your documents, counsel. Will you still question using your own documents? Will you still question the authenticity of your own documents?
Of course not, Your Honor.
Okay,
Of
then
course not,
maybe
counsel.
that is
but
a possible solution, Your Honor. Let us use the defense documents instead of the prosecution documents. Para wag na tayong mag-compare. Thursday, Friday, manonood pa ako ng Odyssey.
I'm sorry, counsel. The presiding officer was not yet elected during the pretrial, hence I did not know what went on during the pretrial. Apparently, the respondent or counsel for respondent has a different purpose and or intention with respect to the ARs from that of the prosecutor. Therefore, that's why they refused a common marking on the same AR.
Yes, Your Honor.
Is that correct? So they have their own set of ARs, and you have your own set of ARs that was marked during pretrial, correct, counsels?
that is correct, Your Honor.
Now, all that the court is asking is for an opportunity to be had by the parties once more to compare your respective marked ARs to be able to distinguish and find out if indeed they are the same or not, regardless of whatever purpose or theory each party may have with respect to presenting the ARs, given that they are common exhibits. We will not touch into that, counsel for respondents. So your concern with respect to authenticity and purpose will not be touched on. Only insofar as that it is the same AR that you received, it is the same AR that you sent to the COA, that you also have a copy of, that they are presenting. And insofar as ARs that you did not send COA or did not come from you, then you can point that out too, as the case may be or as may be appropriate. Again, without any pressure nor any mandate from the court for you to stipulate on all, just the opportunity to do so. Kindly agree on a date, councils, on a time rather, between Monday and Thursday. If that is not possible, then we will continue as we have this afternoon. But kindly agree on a date. Court so directs the parties to fix a date and be able to present the same, be present before the clerk of court to compare the ARs they separately marked and to confirm if indeed which ones are the same and which ones are different for whatever purpose it may serve both parties, given that they are commonly marked. So ordered. Hailin, sorry, babalik ka. Wala tayong magagawa. Court will have to wind up at this point because otherwise we will be continuing with this prolonged marking of evidence, which will not only bore the viewing public but the senator judges as well, the presiding officer and the Senate President included. So we will have to cut it short at this point in time and discuss already some administrative matters before we adjourn in time for our session. Yes, Attorney Gabunan.
Just one more ask, Your Honor.
Yes, ma'am.
Earlier in the proposal for stipulation, counsel for defense kindly was kind enough to stipulate on certain documents, Your Honor, except for 10 documents, Your Honor. Since this opportunity is given by this honorable court to compare, and we understand that their reluctance to stipulate on these 10 documents is because of their claim that it does not faithfully represent the originals, Your Honor. May we ask also that these 10 documents be perused during the period given?
If only to give it a second chance and a second look, given that not much time was given to the counsel for respondents to view it. They were only given 20 minutes. So, yes, the court will allow it to allow the respondents more time to go over it for possible stipulation. Again, no pressure, Attorney Christine. You don't have to if you don't want to. You don't have to if you don't wish to. But the court just wants to give it one more shot to save on the court's time. So ordered.
Thank you, Your Honor.
Now, before the court makes a ruling on the motion for judicial notice, the court promised to hear and listen to the counsel for respondents either in writing or orally. I have been informed by the clerk that no responsive pleading was given by the counsel for the respondents. So I guess you will be
Your Honor, please.
orally arguing the motion.
If I may, Your Honor, please.
Beforehand, I guess you will be orally arguing on the motion for judicial notice, counsel? Attorney Christine?
We are ready, Your Honor.
Your Honor,
Again,
please.
just to hear your side. Yes, Attorney Kabunan.
At this juncture, Your Honor, I respectfully turn over to our public prosecutor and head public prosecutor, Chairman Jinky.
Yes, thank you, Honorable Luistro. Before I recognize you, Ma'am Hailin, you are excused. Sorry po. You are excused, but you are ordered without need for the issuance of another subpoena to appear once again before this court on August 10 and 11. 10, so in open court, you are directed to appear here once again on August 10. We will be issuing another subpoena should we require your presence again on August 11 onwards. Do you understand, ma'am?
Yes po, Your Honor.
So magpapakita po kayo sa Lunes uli nang wala ng subpoena.
Yes po, Your Honor.
Salamat po. You're excused, ma'am, and thank you for your presence and cooperation this afternoon and your patience. Now, this won't be oral arguments. The chair just wanted to hear from the counsel for respondents. So really, this will not be oral arguments between the parties. Yes, what is the position of the council for respondent insofar as certain records of the House Good Government Committee and Public Accountability Committees, if I'm not mistaken. Attorney Christine, you'll be arguing?
Yes, Your Honor.
You may proceed, ma'am, when you're ready.
Thank you, Your Honor. The defense would like to oppose the motion for judicial notice on the following grounds. Number one, the judicial notice rule cannot be taken of disputed matters. Number two, the respondent must be given an opportunity to be heard by way of cross-examination before the court admits in evidence the matters covered by the TSNs, the video recordings, and the committee reports. And number three, the proceedings before the COJ were questioned by the respondent before the Supreme Court as a fishing expedition and mini trial. On the first point, Your Honor, judicial notice cannot be taken of disputed matters. In Juan versus Juan, the Supreme Court defined judicial notice in this wise. Judicial notice is the cognizance of certain facts that judges may properly take and act on without proof because these facts are already known to them. Put differently, it is the assumption of a court of a fact without need of further traditional evidentiary support. The principle is based on convenience and expediency in securing and introducing evidence on matters which are not ordinary and are not bona fide disputed. While the CGGPA and COJ hearings were made public, we do not dispute that, Your Honor. The matters discussed within them, which were documented via the TSNs, video recordings, and committee reports, are not facts automatically admissible in this impeachment trial. Rather, they remain assertions that must be proven by evidence. We note, Your Honor, that Article 1 of the Articles of Impeachment alleges the following: that respondent, Vice President Sara Duterte, committed culpable violation of the Constitution, graft and corruption, and betrayed public trust through the systematic misuse, misappropriation, and irregular liquidation of confidential funds amounting to 500 million pesos, released to the Office of the Vice President, and 112.5 million pesos released to the Department of Education. Clearly, Your Honor, these are not just statement of facts. These are accusations of misuse, misappropriation, and irregular liquidation of confidential funds which must be proven by the prosecution through presentation of evidence. In fact, Your Honor, if you noticed, the prosecution in paragraph 1 of its motion for judicial notice admitted that, I quote, prior to the transmittal of the articles of impeachment to this honorable court, the House of Representatives, through its Committee on Good Government and Public Accountability and its Committee on Justice, conducted official hearings on matters that ultimately formed the factual basis of Article 1. We highlight that, Your Honor, ultimately formed the factual basis of Article 1, which is the misuse and misappropriation of confidential funds. Okay. Article 1 of the Articles of Impeachment as a continuation. These proceedings were officially documented through transcript of stenographic notes or TSNs, official audiovisual recordings, and committee reports. I am just reading, Your Honor, I'm just referring to the motion of the prosecution. Thus, we cannot take the TSNs, the video recordings, and the committee reports as they are, Your Honor, without cross-examining the witnesses of the prosecution. The impeachment court cannot just take the utterances, testimonies, the questions and answers, and the interpellations during the COJ and the CGGPA hearings as factual findings and statements of truth without going through the usual route of evidence presentation. In fact, Your Honor, we are even unsure whether these videos are spliced, edited, or shortened, with due respect, and whether the TSNs are accurate and edited or modified as portions of the TSNs turned out to be different to our transcribed notes, which leads me, actually, Your Honor, to my second point. That because the matters covered by the pieces of evidence, Your Honor, which the prosecution would like this court to take judicial notice are exactly the matters that are being heard before this impeachment court, the respondent must be given an opportunity to be heard by way of cross-examination before the court admits in evidence the TSNs, the video recordings, and the committee reports. The requirement of due process is basic. It is the opportunity to be heard before the court, and affording the respondent the opportunity to cross-examine to cross-examine the authenticating witness serves a dual purpose, Your Honor. First, it validates the existence of the video recordings, the TSNs, and the committee report. And second, it verifies their accuracy and completeness. The Constitution explicitly guarantees the respondent's right to ensure that these pieces of evidence have not been altered, edited, or modified to fit the prosecution's narrative of Article 1. Consequently, the respondent is fully entitled to have all the observations, the objections, and cross-examination questions placed on record before the court admits these documents in evidence. It is also a matter of record, Your Honor, that the videos that the prosecution would like this court to take judicial notice were not played during the pre-trial conference, Your Honor, and it is with the understanding between the parties that there shall be subjected to proper authentication and identification during trial, consistent with the rules of court. And third, the respondent has directly challenged the House of Representatives Committee on Justice proceedings before the Supreme Court, Your Honor, characterizing them as a mere fishing expedition and an authorized mini trial, Your Honor. Consequently, the respondent declined to participate in these proceedings, maintaining that the HOR-COJ lacks the jurisdiction to conduct these trials. Under Article 9, Section 3, Paragraph 6 of the Constitution, the respondent submits that exclusive power and authority is vested solely with or in the Senate, Your Honor. That's why a petition for certiorari and prohibition was filed by the respondent before the Supreme Court. So we cannot stipulate, Your Honor, on the matters that were taken up in a proceeding that the respondent challenged before the Supreme Court. But crucially, Your Honor, the petition pending before the Supreme Court challenges the proceedings before the HOR-COJ only and not the actions of the Honorable Impeachment Court. This distinction, however, does not preclude any future legal challenges against actions that this court may take while sitting as an impeachment court. The respondent, Your Honor, was consistent in her position, Your Honor. In fact, in a letter dated March 24, 2026, the respondent through counsel informed the HOR-COJ that she cannot attend the mini trial and the fishing expedition being done by the said committee because of the committee's apparent lack of authority under the Constitution. The closing paragraphs of the letter state, and I will read the closing paragraphs for the record. In light of this, while the invitation for the respondent and counsel to participate in the committee's mini trial is well noted, we cannot, however, do so at this point on the ground that the committee and/or the HOR, as well as any of its members, lack jurisdiction to conduct any form of trial or exercise any of its incidents. Absent such jurisdiction, any attempt to proceed in the nature of any form of trial or invoke powers ancillary to it is unconstitutional. Consequently, the respondent puts on record her objection to any requests, motions, or similar efforts aimed at obtaining or fishing for supposed evidence through processes that necessarily presuppose the existence of lawful authority and jurisdiction under the Constitution, which in this case is absent. As timely stated in the appearance and consolidated answer, both made ad cotelem, the respondent does not waive any jurisdictional or other objections she has to these proceedings, nor her right to seek the appropriate legal remedies. Nonetheless, she is prepared to meet the charges against her in proper jurisdiction. And because of that, Your Honor, the court must decline to take judicial notice because the very validity and authority of the the House of Representatives COJ proceedings are currently challenged before the Supreme Court. Now, on closing, Your Honor, on its face, actually, the motion may look like a plea for this honorable court to take judicial notice of the purported official legislative acts described by the prosecution. However, Your Honor, if you really examine the motion, Your Honor, in reality, however, the motion is actually akin to a public prosecutor, the House of Representatives, asking the criminal court, here the impeachment court, to take judicial notice of the complaint that was filed before the fiscal, here the HORCOJ, and all matters related thereto, including those that transpired during the preliminary investigation without the need for presenting witnesses in court. That is actually what the prosecution is doing in our view, Your Honor. Dahil ang mga pandinig na ito sa House of Representatives ay siya mismong paksa ng paglilitis ng hukumang ito, at ayon mismo sa prosecution, those hearings became the factual basis for Article 1 of the Articles of Impeachment. Nararapat lamang po na ang mga TSNs, video recordings at committee reports na naglalaman ng mga tanong ng kongresista, pati na ang mga pahayag at sagot ng mga testigo ay patunayan ng prosecution sa pamamagitan ng pagpresenta ng testigo upang magpatunay sa katotohanan ng mga ito. In closing, Your Honor, would like to quote the Supreme Court in Juan versus Juan. The Supreme Court said, the article in the website cited by the RTC patently lacks a requisite for it to be of judicial notice to the court because such article is not well and authoritatively settled and is doubtful or uncertain. It must be remembered that some articles appearing in the internet or the websites are easily edited and their sources are unverifiable. Thus, sole reliance on those articles is greatly discouraged. The defense opposes the motion, Your Honor, on identical grounds. Salamat po.
Again, these are not oral arguments, counsel. Chair had anticipated the position of the counsel for respondent. In fact, Chair would like to clarify. The Juan versus Juan case is the Lavandera Co case, right?
Yes, Your Honor.
Ito yung Lavandera Co na kumpanya na nireklamo violating copyright standards. Hindi ba na nag-judicial notice yung korte sa isang internet website na may copyright daw yan?
Tama po.
That is the case. Okay, Chair will now make his ruling. First, with respect to the motion to set the conference for marking objected to by respondents insofar as number 3 is concerned. P4-35 to P4-35B, but did not object to the others. So the request for transfer of markings this afternoon, insofar as the unobjected portions are granted, insofar as the objected portions are concerned, Chair will make a ruling. We will furnish the respondent and the prosecution with the written copy of the ruling through the journal of this court. The Chair will now resolve the panel of prosecutors' motion to set the conference for the transfer of exhibit markings, particularly on exhibits P-4-35 to P-4-35A and P-4-35B, which refer to the portions of the purported affidavit of Arturo Las Cañas. And after considering the objections of the Chair of the respondent, the objection is hereby denied subject to the following guidelines and reasonings. Section 34, Rule 132 of the Rules of Court provide, the court shall consider no evidence which has not been presented or formally offered. The purpose for which the evidence is offered must be specified. Accordingly, the marking, identification, or authentication of a document does not mean that the document has been formally offered or admitted for the purpose it was so stated. The physical transfer of an exhibit, designation from a provisional copy to its corresponding original or certified true copy is even more limited. It is a mechanical and ministerial act intended only to maintain the orderly identification of the court's records. The respondent is not prejudiced by this transfer. The transfer does not alter the substance or evidentiary status of the document, referring to the Las Cañas document. It does not constitute a ruling on the authenticity, admissibility, or evidentiary weight, and it does not enlarge the purpose for which the document was originally marked. The respondent therefore loses no substantive or procedural right by reason of the transfer and may raise all appropriate objections when the document is formally offered. This conclusion is consistent with the prosecution's own representation during the July 21, 2026 hearing, wherein the Honorable Luistro stated, quote, "Your Honor, the document is being presented only to seek confirmation from the witness that he is referring to this particular document as part of the investigation of the Special Task Force. We are not presenting it to prove the truthfulness of the contents of the affidavit." Close quotation. The chair likewise previously ruled, quote, "Again, this is only as to the fact that this is what the NBI used in their open investigation and coming up with their findings, not as to the truth of the statements being read by Director Matibag." Close quotation. The chair further clarified on even date, July 21, 2026, the chair will cut short any further identifications of the witness in regard to this affidavit. This is only as to the fact that Las Cañas executed a document that they used in their open source investigation, not as to the truth of what was said. The limitations remain controlling even after the transfer of the marking of this exhibit to a certified true copy. Exhibits P-4-35, -35A, and -35B remain merely independently relevant statements only to establish that the document came to the attention of and was used by the NBI in its investigation. It may not be used as proof of the truth of the allegations stated therein. As stated in Espinelli versus People, GR number 17535, dated 6/9/14, when the relevant fact is merely that a statement was made, the hearsay rule does not bar proof of that fact, regardless of the statement's truth or falsity. Finally, the transfer of the markings does not cure the defects already placed on the record. The purported affidavit remains unsigned, unnotarized, and not made under oath, with no witness having attested to its execution and truth of its contents. The contents of the affidavit at this time remain hearsay, the transfer of the markings notwithstanding to a certified true copy of that document. Accordingly, the clerk of the impeachment court is directed to set the requested conference as requested, I think, this afternoon, if I'm not mistaken, at 4 p.m. Now, on the motion for judicial notice, the chair will make a ruling, will grant the motion with a reminder, a stern reminder and warning. The court acting on the motion for judicial notice dated August 3, seeking judicial notice of the existence and official character of the hearings and the corresponding transcripts, audiovisual recordings, and the committee report identified therein. Section 1, Rule 129 of the rules provide, a court shall take judicial notice without need of the introduction of evidence of legislative, executive, and judicial departments of the National Government of the Philippines. As stated in CLT, the case cited by the counsel for the prosecutors, there is such, referring to a Senate committee report. The court took judicial notice of the Senate committee report, but only as to the existence of the committee report and not as to the content and truth of what was stated in the committee report. Therefore, accordingly, the court granted solely and exclusively limited to the following facts. Number one, that the legislative hearings were actually held and under the official function of the House of Representatives, Committee on Good Government and Public Accountability, and the Committee on Justice. So to reiterate, just as to the factual existence that the hearings were indeed conducted. Number two, that the corresponding transcripts, official audio records of the proceedings, and in a separate rule, therefore enjoy the regularity of official proceedings. Proof that there is either fraud, falsity, or inaccuracy and therefore which will overcome the presumption of regularity. With a warning, having granted the motion only within the foregoing limits, the chair now states in unmistakable terms the precise effect of this ruling and reminds the prosecution, and should the time come, also the respondent, if they happen to cross this line also, Rule 129 is captioned, "What need not be proved." Therefore, the court states with precision what the prosecution need not prove, only with respect to those two things. Nothing else is judicially admitted or established. The prosecution is therefore expressly, it says warned here, but I would rather say reminded, that judicial notice shall not be used as a vehicle to place into the record substantive contents of the transcripts, recordings, or it is not a with the applicable rules on authentication, hearsay, relevance, and the right of the respondent to object and confront the evidence presented against her. As the Supreme Court held in Magsisimula versus IAS, PIDEA, GR number 198140, 12516, fair play requires that the respondent be given meaningful opportunity to rebut all the evidence presented against her. Therefore, consistent with the chair's prior ruling on July 21, in relation, a witness will not hereafter be allowed to read in open court his or her own, as the respondent will and cross-examine the statements made by a third party. Again, to reiterate, the court does not take judicial notice of the truth of any statement made during the hearings, allegation, or the validity of any finding or conclusion in the committee report. Those matters remain subject to proof, objection, and the court's independent evaluation of their admissibility and or evidentiary weight at the time. The prosecution shall not that this ruling establishes the truth of any matter contained in the identified. This judicial notice given for that purpose shall be rejected by this court, and the parties accordingly shall be duly reminded in course. So ordered. There being no prosecutor, your witnesses for next week, before we call it a day, a rainy day.
Your Honor, we have to submit the following witnesses for next week. That is August 11, August 12, and August 13. August 10. And of course, is Silene May L. Del Campo from ICFAO, our today. 2 is Marivic Pareja from Legislative Information Resources Management Department of the House of Representatives. 3 is Gina S. Acosta, former Special Disbursing Officer of the Office of the Vice President. And the 4th, Your Honor, is Edward D. Fajarda, former Special Disbursing Officer of the Department of Education. That is all, Your Honor.
Let the corresponding subpoenas requested ad testificandum and or ducis tecum, as the case may be, issue to the aforementioned witnesses for the dates and times given and requested by the lead prosecutor for the impeachment trial next week. Again, counsel, just a reminder, if you will be having documents that you would want opposing counsel to stipulate on, kindly give them a copy at least a day before so that they can already manifest in open court their agreement or disagreement with the proposed stipulation. Counsel? Yes?
We confirm, Your Honor.
Thank you. Any other matter you wish to mention, Attorney Christine?
None from my
Chair adjourns. There being no other business to be taken up by the impeachment court at this time, the trial is hereby adjourned until 10 a.m. of Monday, August 10, 2026.
COA ICFAO hanggang sa susunod na linggo at sa kanila ito ipagpapatuloy pagkatapos ng stipulation ng karagdagang mga dokumento. Pinagbigyan din ng impeachment court ang motion for judicial notice ng prosekusyon para sa mga dokumentong may kinalaman at nanggaling sa House Committee on Good Governance and Public Accountability hearings. Pero ang paglilinaw ng impeachment court, hindi ito nangangahulugan na tinatanggap nila bilang katotohanan ang nilalaman ng mga committee report at iba pang dokumento. Ang paglilinaw ng impeachment court, ang motion for judicial notice is granted and limited korte, yung objection ng depensa patungkol naman sa Las Cañas affidavit dahil ang sabi po ng presiding officer na si Chis Escudero ay yung mga objections naman po during offer of evidence pwede pa pong gawin ng depensa at gaya daw ng sinabi niya nung una, tinatanggap nila ang Las Cañas affidavit hindi dahil sa nilalaman.
Some days can get a little crazy. But with Food Panda, there's always something flavorful to steady your day. Make life delicious.
The Philippines University. Dean Sol, thank you very much.
Thank you very much for
joining us
inviting me
today.
too, and thank you for allowing me to serve the country. Thank
Maraming
you.
salamat po din.
Salamat.
Dahil nalinawagan po at nalinawan po kami ngayong araw dahil po sa inyo.
Thank you.
Mga kapuso, yan po ang special coverage ng GMA News sa Day 13 ng impeachment trial ni Vice President Sara Duterte. Maraming salamat po. Ako po, the Vice President on trial.